on this episode of Charged and Disbarred.
Michael Morton was a classic innocence case. His wife was murdered.
You have the loss of 25 years of Michael Morton's freedom, which also deprived him of his right to be a father to his son.
And if any evidence gets in the way, you get rid of it. They knew the DNA cleared it. They knew it. But they were fighting its use in court with every effort he made blocked and stymied by the state of Texas.
Judges and attorneys are like kings and knights in their own realm. It is unthinkable that in a moment of madness it can all be thrown away. Charged and Disbarred explores the true life stories of attorneys who have fallen from grace. Hear firsthand accounts from the victims, detectives, and prosecutors who brought these disgraced attorneys to justice. This is Charged and Disbarred.
The great state of Texas, famous for cowboys, football, and black gold. It is known as the Lone Star State, referring to the single star on the state flag. The star is a symbol that represents a cultural attitude of defiance, pride, and most importantly, independence. This attitude is perfectly summed up in the famous phrase, "Don't mess with Texas." It is therefore understandable that when it comes to criminal law, there is a no-nonsense approach in Texas. In Texas, any kind of criminal offense is treated with severe punishment. This is reflected by the fact that since 1976, 40% of all capital punishment executions in the United States have taken place in Texas. Added to that, the incarceration rate of Texas is the fourth highest in the U.S. It therefore seems Texas would be a great place for families to live, a safe place to live, especially having a highly functional and effective judicial system with fair laws that punish the guilty. But what happens if you're charged for a crime that you did not commit? Will the judicial system in Texas give you a fair trial?
My name is Michael Morton, and I did 24 years and 7 months to the day in TDC.
The Innocence Project of Texas was different than a lot of other innocence projects. All innocence projects have in common that they work on cases of people who are in prison, who are claiming that they're innocent, and all innocence projects have in common the goal of getting them out. Texas is a whole other kind of problem. Texas is a state that is deeply committed to injustice, deeply. We have 160 to 170,000 people in prison on any given day. We have no public defender system. We have a court system that is a joke, that's politicized, that goes out of its way to keep people locked up no matter how bad the facts in the case are, no matter how innocent they may be. Our work there basically consisted of building a civil rights organization, an impact organization that could take individual cases and use them as a way to expose the system and then begin to make bigger and deeper changes. So from the beginning, the Innocence Project of Texas was extremely devoted to changing the legal system so that people going forward could get a fairer deal, more due process, more justice, less injustice.
In the great state of Texas, it is possible to go to jail for a crime one did not commit. Some are denied the basic right to a fair trial. Inside this flawed judicial system, there is a prevailing culture that rewards verdicts of guilty over justice and truth.
Michael Morton was a classic innocence case. He was a guy who went through a criminal tragedy where his wife was murdered. Early on, the police jumped to a conclusion and put it out there publicly that it was him.
Neighbors told me that in the very first hour, before they did any investigations, before they did any interviews or lab tests, or even spoke to me and informed me of my wife's death, the police were looking around and saying, "Oh, the husband did it, this is easy."
This is the same pattern in every single case we've had over and over and over, dozens of them. The whole system backs that cop up and says, you know what, you're right, it's got to be that guy. And if any evidence gets in the way, you get rid of it. That's how perverse our legal system has become.
On the morning of August 13, 1986, the day after his birthday, Michael Morton got ready and left for work at 5:30 a.m. In his mind, it was just another day living a very normal life in the heart of Texas. He was married, had a son, had a job, and lived in a typical suburban home. He often expressed just how normal his life was, like taking a page from a sociology textbook describing the demographic of an average white middle-class family living in Texas. His life, however, still in the midst of suburban bliss, would take a turn for the absolute worst and be unequivocally changed forever. Later that morning, a neighbor had seen their 3-year-old son wandering in the garden unsupervised and looking disheveled. Upon further investigation, the neighbor discovered Morton's wife's body in their bed having been bludgeoned to death by a blunt object like a piece of wood. That afternoon, when Michael arrived home, he was met by the local sheriff. Right from the beginning, he was a suspect. Even the tone of questioning towards him was accusatory instead of inquiring. The police did not inform him of his wife's murder. He was blindsided, confused, and in shock as they berated him with questions without a lawyer present. 6 weeks later, he was arrested for his wife's murder, and as his son was being ripped from his arms screaming, Michael Morton was cuffed and driven away in a squad car. A year later, on August 17, 1987, even though no murder weapon was found and the prosecution failed to present any direct evidence linking Morton to the crime, he was found guilty of murdering his wife. The prosecutor, Ken Anderson, argued persuasively, accusing Michael Morton of being violent and unremorseful. Anderson's leading argument was that Morton had killed his wife because the night before her murder, she had turned him down for sex. Anderson's theory was based on a note that Morton had left his wife before he left for work. The jury, persuaded by a highly emotional and extremely theorizing closing argument by prosecutor Ken Anderson, found him guilty. He was sentenced to life in prison. Morton and his defense lawyers were shocked. However, both he and his defense team had long suspected that there was crucial evidence being withheld by prosecutor Ken Anderson, evidence that would have exonerated Michael Morton. A part of this suspicion stemmed from Ken Anderson deliberately denying the defense team full access to the police reports in the prosecutor's file. It was Ken Anderson's modus to create as unfair a playing field as possible in favor of the prosecutor. It was part of his well-known closed file policy. Was it possible that these files contained exculpatory evidence?
It was as if you're playing cards for money and the prosecutor is dealing. But not only is the prosecutor dealing the cards, he's also looking at the cards and deciding whether or not you should get them. And that's a definite conflict of interest. So he's basically stacking the deck for his own case.
The evidence that the defense never got access to included, among other things, a bloody blue bandana. A bandana that was found at a construction site 100 yards from the Morton residence. A piece of evidence that was ignored by the police, but later on collected by Christine Morton's brother, John Kirkpatrick. There was a statement taken by the police from Michael Morton's mother-in-law, Rita Kirkpatrick. She had spoken to the Morton's 3-year-old son, Eric, and he said that he was present during the murder of his mother. He had told his grandmother that Daddy was not home, and that a monster with a mustache had hurt Mommy. Eric described the crime scene and suspected murderer in detail. Rita Kirkpatrick's statement was made to Sergeant Don Wood, the investigating officer. Also, a statement was taken by the police from the Morton's neighbors. They described the man repeatedly parking a green van behind the Morton's house the morning of the murder. Finally, it had been reported that Christine Morton's credit card had been used in San Antonio a few days after the murder took place. None of this evidence was turned over to the defense team prior to the trial. Their suspicions were confirmed when they discovered that the prosecution decided not to call Sergeant Don Wood, who was the chief investigator in the case, to the stand. When the defense informed the trial judge of their suspicions, he ordered that all the reports by Sergeant Wood be turned over to them so they could carry out their own detailed review of the reports. It is important to note that none of this evidence was in the records given to the judge.
When they opened it and it was supposed to be the DA's file on me, this particular part was like 3 to 5 pages. And it was supposed to be in the sheriff's notes and records of this murder investigation. And clearly a 6-week murder investigation is more than just 3 to 5 pages. Lots of things that were not in there.
In my opinion, Sergeant Don Wood most likely ignored a lot of these clues because the simplest answer is usually the most likely one. Incompetence, confirmation bias as well. You have something that you think is the truth, and you're going to work towards that no matter what else you see. You've seen it, like Jeff said, in 1,000 other cases, all these cases. You think you have your suspect, and you have your theory, and that's going to be your theory, and that's what you're going to do with it.
It is obvious, however, that one can't put the blame exclusively on one investigating officer's incompetence. There had to have been more players involved. Whether Sergeant Wood's investigation was done in an incompetent manner or not makes no difference to the fact that there was a real possibility that Ken Anderson deliberately withheld crucial evidence from the defense team and the presiding judge.
I don't know how that could happen, how Judge Anderson could have made the decision that he did in this case to at least be aware of evidence that indicated that somebody else was responsible for the death of Mrs. Morton, and then turn around and essentially frame and railroad her husband into this. It's just beyond the pale how anybody could do that, especially an individual who has taken a sworn oath to seek justice and not convictions.
So who is Ken Anderson, and what could possibly have been his motivation for his intentional disregard of his legal and ethical obligations to disclose this evidence? Ken Anderson moved to Texas as a teenager, and after he finished high school, he decided to study law at the famous University of Texas at Austin. While there, he received a Bachelor's of Science degree and a Juris Doctorate. He was admitted as a lawyer to the State Bar of Texas in 1976. He spent 22 years of his career as a prosecutor, of which 16 and a half years was as district attorney. In 1995, about 8 years after the Morton conviction, Ken Anderson was named Prosecutor of the Year by the State Bar of Texas. A stellar career indeed. But there was a mean streak to Ken Anderson, which was cleverly disguised in his image as a fair man looking to uphold the law through truth and justice. He was the good guy looking to catch the bad guys. He, however, had a reputation as a hardline prosecutor who often fought to get harsher sentences than that suggested by the court. As a result, Anderson quickly developed a reputation as an unforgiving lawman who was known to have actively fought to keep prisoners in jail long after they had become eligible for parole. Regardless of his harsh approach, in 2002, Governor Rick Perry appointed Anderson as a judge to the 277th District Court in Texas. The question still remains, why would a lawyer as experienced and accomplished as Ken Anderson be motivated to withhold crucial evidence?
Most people's motivations are about as base level as you can get. If it's a I'm going to win or I'm going to lose, which most of the systems in Texas are that way, it's all politicized. But when you're motivated to win and have a positive record, that distorts all sorts of things. And when you can't hold someone responsible, there's no meaningful punishment for bad behavior, this is what you get.
Texas, like some of the other ex-Confederate states, is truly awful, okay? We encourage, we reward, we facilitate bad behavior by lawyers every day. I mean, this is what we do. If you are a court-appointed lawyer in Texas and you try to do a good job, you will not be a court-appointed lawyer for very long because there's too many people that have to get run through the system. The job of the court-appointed lawyer in Texas is to help the judges run those people through the system. That's where it starts. For prosecutors, there's no punishment for being bad. There's a lot of reward for winning. And if you need to be bad in order to win, well, so what? Nothing's gonna happen to you except a cush job that you've just gotten reelected to, or maybe a judgeship like Ken Anderson. We have elevated the art of being bad here to a positive, no-lose situation for bad lawyers and bad people. We enshrine this. I mean, lawyers that try to stand up and do the right thing, they not only get no reward, they get castigated by the system, criticized, isolated. When you create a system like that, you're gonna get a lot of bad behavior, and you're gonna get really bad lawyers. And that's what we have here. We are plagued with it in Texas.
Another possible explanation for Ken Anderson's behavior was that he had been the district attorney for only a year by the time Christine Morton was murdered. He was 33 years old and had never run for public office before and knew how good a conviction would look on his resume for future electoral campaigns. In the years that followed, he would often refer to the Morton case as a highlight of his 22-year career as a prosecutor, a dead giveaway of what possibly motivated him. The dilemma, however, for Michael Morton was that it didn't change anything knowing that he was innocent. The reality was that in the eyes of the law, he was a convicted murderer and was going to spend the rest of his life in jail.
I thought it was going to be a rough trial. It was going to be hard on me, but I figured in the end it would work out. And the guilty verdict was like a physical blow. You're numb and you're hurting. You can't believe it, and yet it's very, very real. It's right there.
Then a few years later, the unthinkable happened. Morton received a letter from his son, who by now was 15 years old, asking if he could be legally adopted by his aunt, Mary Lee Kirkpatrick. Unfortunately for Michael Morton, because the court had found him guilty, his son grew up believing his father had brutally murdered his mother. It was understandably a logical step for his son to move on with his life. It was a devastating blow, but the only way to survive was to hold on to something dear to his heart, like a dream of mending a broken relationship once he got out. For Morton, the answer was obvious. First, he wanted to prove his innocence, but most importantly, he wanted to hold on and get through this nightmare for his son.
It is just absolutely tragic what has occurred here. You have the loss of life with Michael Morton's wife. You have the loss of 25 years of Michael Morton's freedom, which also deprived him of his right to be a father to his son. And then you have the son, who obviously has a very strange and essentially at some point then just a totally non-existent relationship with his father, Mr. Morton. So the son has essentially been left orphaned by this process.
But there was still the chance of a retrial. Scientific and technological advances have been made in the field of DNA testing. What if he could be proven innocent through DNA testing? There was a sliver of hope. Another obstacle that Morton faced was who would represent him in such a trial. He had by now been in prison for years, and as such would not be able to afford a decent lawyer who would be up to the task. Fortunately for Michael Morton, the world seems to, in the long run along the lines of grace. That grace came in the form of the Innocence Project. The year was 2002. Michael had by now been in prison for 15 years, and over the years, numerous requests by his defense attorney for a retrial had been made but ultimately turned down. Now, however, the Innocence Project's involvement in taking on Michael's case would change everything.
This is Charged at this bar.
Michael Morton is a good man. He was an easy target. The cops made a mistake, and the result was that it cost him 25 years of his life. 7 years of that 25 he spent trying to get himself out. And it wasn't just Ken Anderson who had originally framed him. It was the later prosecutor helping Anderson, who's now a judge, and looking out for the state and trying to prevent Morton from having that evidence tested for DNA. There were DNA tests. They would have cleared him. 7 years he spent in prison trying to get that happen, with every effort he made blocked and stymied by the state of Texas.
The prosecutor who was fighting Morton's lawyers so vehemently regarding the DNA testing was the Williamson County DA, John Bradley. He had served as Ken Anderson's loyal first assistant for 11 years. When Anderson became a judge, Bradley took over as DA. John Bradley had been groomed in the school of thinking of Ken Anderson. Many people had commented of Bradley being just as unforgiving as Anderson, but a lot louder. He personally spent 7 years fighting the Innocence Project's efforts to exonerate Michael Morton based on DNA evidence.
John Bradley is an extremely smart guy, probably smarter than Anderson. besides the fact that he was the statewide spokesperson for all prosecutors year in and year out, he was the go-to guy that would speak for the ethical standards of all prosecutors in Texas. He wasn't just a prosecutor, he was like the Uber prosecutor in Texas. He was the biggest deal prosecutor of all the prosecutors, the president of their association, and made a lot of hay out of that. Now, understanding that, so now we have the spokesperson for all prosecutors. What's he really doing with his actions? Keeping an innocent guy in prison for 7 years, a guy he knows is innocent, obstructing the process of getting him out, claiming there was no reason to do DNA testing, and he knew the entire time he was innocent. He had that file in his office. That's a level of evil.
But even in the great state of Texas, the wheels of justice turn ever so slowly, but they turn. Morton's lawyers eventually had obtained the necessary permission to have the DNA that was collected from the crime scene of the Morton's residence tested. Their efforts, however, to have the bloody blue bandana tested that was found 100 yards from the Morton's house a day after the murder were blocked by Justice Stubblefield, the presiding judge. It was the same blue bandana that was never disclosed as evidence to Morton's original defense team. Unfortunately for Morton and his legal team, the first set of DNA tests did not reveal any new evidence. It was therefore crucial for them to get permission to have the blue bandana with small bits of dry blood on it tested. In the meantime, John Bradley was publicly stating in newspapers that he believed that the defense team was clutching at straws and looking for a mystery murderer. It would take Michael Morton and his defense team an additional 5 years fighting the DA's office before DNA testing was permitted on the blood-stained blue bandana, a total of 7 years. It was only in January 2010 before the Third Court of Appeals would overturn Judge Stubblefield's previous decision, thus giving permission for testing to begin on the blue bandana. It was a massive victory for Morton and his team. There was, however, a real tragedy playing itself out in the background. The reality was, if Michael Morton was innocent and not guilty of killing his wife, then who was? Surely there was a killer out there who had not faced justice for a heinous crime committed 25 years before. Could it be the monster with the mustache that Eric Morton had told his grandmother about all those years ago? And if so, what had he been up to?
Mark Norwood, who killed Michael Morton's wife, gets to go free for that crime because of the bungling of the police and the lying of the prosecutors. And then while they were fighting to keep Morton in prison for 7 years, even though they knew the DNA cleared it, they knew it, but they were fighting its use in court, Norwood goes out and commits more crimes, including murder. Now that is about as shameful an act of government as I can think. That is the opposite of protecting and serving, and it was all done on the altar of the egos of Ken Anderson, the prosecutors involved, and also the state of Texas. They care more about their reputation and their image than they do about whether people are safe from crime in this state.
John Bradley, who was the district attorney there in Williamson County, intentionally delayed the process for as long as he could. I think that Mr. Bradley was aware that there was exculpatory evidence in the file. I think that that led him to the conclusion that there was going to be exculpatory evidence when the DNA results came out. It was going to indicate that his predecessor, Judge Anderson, and now he had been responsible for confining an innocent man in prison for 25 years. And so I think that he delayed it as long as he could for those reasons and probably also for political reasons.
After waiting for another year after permission originally was given for the DNA test to be done on the blue bandana, the results came back positive. The blood on the bandana was that of Christine Morton, and also present was traces of DNA of a man that was not Michael Morton. When the unidentified male's DNA was entered into the CODIS DNA database of the FBI, an immediate and definitive match was made. That of Mark Allen Norwood, a known felon with an extensive criminal record stretching from arrest in Texas, California, and Tennessee. The various charge sheets included crimes for aggravated assault with intent to kill, drug possession, arson, breaking and entering residences, and resisting arrest. Mug shots of Norwood revealed a mean-looking man with a big mustache. There could be no more doubt that Michael Morton was an innocent man and he did not murder his wife. District Attorney John Bradley had no more legs to stand on and he finally relented. So on October 3rd, 2011, on a beautiful sunny day, after spending 25 years locked up in prison, Michael Morton was released. In his closing comments, Justice Hurl said, "We do not have a perfect system of justice, but we have the best system of justice in the world." In the aftermath of the Michael Morton case, the Court of Criminal Appeals overturned Michael Morton's conviction on grounds of actual innocence. This posed a big problem for Ken Anderson because he had secured a guilty conviction of a man who was indisputably innocent. It became embarrassingly obvious that he only achieved this because he had deliberately withheld exculpatory evidence.
Just before I got out, the Innocence Project had filed a Texas Open Records Act request with the county and received the file from the sheriff and the prosecutor from back in '86 and '87. But in it, we found all the exculpatory evidence that had not been turned over. And that was a game changer along with the DNA. When a prosecutor lies to a judge about exculpatory evidence, that opens it up to contempt of court.
An investigation into Ken Anderson's alleged misconduct was immediately launched. Shortly after that, Judge Harrell suggested that the Texas Supreme Court conduct an inquiry regarding the actions of Ken Anderson. It took 10 months for the Texas State Bar to complete the inquiry. Their report concluded that Ken Anderson had deliberately withheld evidence and that disciplinary charges would be brought against him. For withholding exculpatory evidence in the 1987 trial of Michael Morton, Anderson was found to be in criminal contempt of court, which is a felony. Anderson, however, made a plea deal agreeing to surrender his law license, which equals disbarment. He was fined $500 and had to serve 500 hours of community service.
Here's what the great state of Texas did to Ken Anderson in the end. He is officially retired, making, I think, well into six figures every year. He did, of course, his devastating 26 hours in jail. I'll bet you they never even put an orange uniform on him, and probably brought him in hamburgers or something from outside. He remains well regarded by prosecutors who think he got a raw deal.
I don't know that Ken Anderson feels any remorse other than the fact that he got caught and he was disbarred and suffered the shame and humiliation that comes from that. But I don't know that he has any true remorse for what he did in this case, or for what happened to Michael Morton, or to what happened to Michael Morton's son.
Ken Anderson to this day has never publicly accepted personal responsibility for his crime or admitted to the misconduct. Ken Anderson blamed the system for inflicting the injustice that Michael Morton had to endure.
The biggest danger of putting the wrong person in prison is perfectly illustrated by me. Because while I was in prison, the guy that really killed my wife killed at least one other woman. Transparency and accountability work not just for the prosecution, but for the defense. And when the playing field is balanced, the system works.
In 2013, the Texas legislature enacted the Michael Morton Act, Senate Bill 1611, effective January 1st, 2014, which requires prosecutors to give defense attorneys any evidence that is relevant to the defendant's guilt or punishment.